Hello viewers and hello students, this is Bishaldeep Kakati and today I'll be dealing with one of the most important aspect of the Indian Constitution, that is the writs, which is basically dealt in Article 32 and 226 of the Indian Constitution. This part is actually very important when we talk not only of preparing for the semester examinations, but it is also important when you go for any competitive examinations, be it the judiciary, be it the NET or any type of government jobs that you appear for. As such, this particular aspect of the Indian Constitution, this particular thing is very important. So basically today we'll not be going into detail or into too much of depth into this particular topic of writs of the Indian Constitution, but we'll be trying to basically deal with the basic concept of this writs that are available in an Indian Constitution, which further will help you to prepare for examinations. And once you develop the basic concept of this writs, it will become easier for you to understand these writs which are available in the Indian Constitution. So basically, before starting with the writs, as I have written writs under Indian Constitution, we need to understand as to how these writs can be applied and what is the basic necessity of including writs in the Indian Constitution. So as you all know that the Indian Constitution gives us certain rights which are known as the fundamental rights, and each and every citizen of India, each and every citizen residing in India who has got the citizenship rights of India has the right to enjoy these fundamental rights. But at the same time, if at certain point or if at any instance these particular fundamental rights are violated, then what is one basic resort that we go to, and that is the reason we go to the writs. And if someone's fundamental rights are violated, especially in India, we have the provision of writs under the Indian Constitution. বিশেষকৈ আমি আজি কথা পাতিম এই ৰিটস গেটাৰ বিষয়, আৰু যেতিয়া আমি ৰিটস গেটাৰ কথা পাতিম আমি অলপ প্ৰথমতে জানিবলৈ চেষ্টা কৰো যে আমাক ৰিটস গেটা কিয় লাগে আৰু কেনেকৈ আমি এই ৰিটস গেটা ব্যৱহাৰ কৰিব পাৰিম। গতিকে বেসিক্যালি এই ৰিটসবোৰ হয় কি, আসলতে কিয় দিয়া হয় আৰু কোনে দিয়া হয়। আমাৰ সংবিধানৰ আৰ্টিকেল বা অনুচ্ছেদ 32ত আৰু অনুচ্ছেদ 226ত আসলতে আমি এই ৰিটস গেটাৰ কথা পাওঁ, আৰু ৰিটস গেটাৰ কথা বিশেষকৈ যেতিয়া আমি পাতিম, but when we talk about this writs actually there is a very important aspect related to it. যেনেকৈ অনুচ্ছেদ 32ত আমি কওঁ যে এই ৰিটসবোৰ অনুচ্ছেদ 32ৰ জৰিয়তে সুপ্ৰিম কোৰ্ট অফ ইণ্ডিয়া অৰ্থাৎ ভাৰতৰ উচ্চতম ন্যায়ালয়ে যদি ৰিটস এপ্লাই কৰিব লাগে, যদি সৰ্বসাধাৰণৰ মৌলিক অধিকাৰ ভংগ কৰা হৈছে, তেতিয়াহলে অনুচ্ছেদ 32ৰ জৰিয়তে সুপ্ৰিম কোৰ্টে এই ৰিটসবোৰ এপ্লাই কৰিব পাৰে। ঠিক তেনেদৰে if your writs are violated in a particular state that you are residing, then under the provision of article 226 of the Indian Constitution, a high court of a particular state can apply these writs. গতিকে এটা প্ৰশ্ন খুব আহে, আৰু সেই প্ৰশ্নটো হৈছে যে আমাৰ বেসিক ডিফাৰেন্স বিটুইন অনুচ্ছেদ 32 আৰু অনুচ্ছেদ 226, অৰ্থাৎ what is the basic difference between article 32 and 226 of the Indian Constitution, আৰু সেইটো বেসিক ডিফাৰেন্স আৰু কেইটামান আছে তাৰ একদম সুপ্রিম আৰু একদম মেইন বেসিক ডিফারেন্স কনসেপ্ট ডিফারেন্সটো হৈছে যে আন্ডাৰ আৰ্টিকেল 32 of the Indian Constitution, Supreme Court of India can apply the writs if someone's fundamental rights are violated, and under article 226 of the Indian Constitution, High Court can apply the writs if someone's fundamental rights are violated. So basically what is a writ? A writ basically, মই এটা লিখিছো, writ basically is an order given by court to a person or authority or both to perform in a specific way. So গতিকে writs কি হয়? Writ basically হৈছে যে কোৰ্টে দিয়া আমাৰ অৰ্ডাৰ এজন মানুহকো দিব পাৰে বা এটা বডিক দিব পাৰে বা অথৰিটিকো দিব পাৰে, মানুহ বা অথৰিটি দুটাকে দিব পাৰে যে আপোনালোকে বা হে বডিটোৱে বা হে পাৰসনটোৱে ইন এ পাৰ্টিকুলাৰ অৰ ইন এ স্পেসিফিক ওয়ে ফাংশন কৰিব লাগিব। সো what are writs? Writs are basically order given by courts to a person or authority or both to perform in a specific way. খুব সহজ ভাষাত যদি মই কওঁ, আপোনালোকে সকলোৱে জানে যে কোৰ্টত আমি তেতিয়াহে যাওঁ যেতিয়া আমাৰ ফান্ডামেন্টাল ৰাইটছবোৰ ভায়োলেট হয়, আমাৰ ওপৰত কেতিয়াবা ইনজাস্টিস হয়, তেতিয়া আমি কোৰ্টত যাওঁ আৰু ৰিটছৰ জৰিয়তে কি কৰে, কোৰ্টে কিছুমান অৰ্ডাৰ দিয়ে, অৰ্ডাৰ দি সেই ব্যক্তিজনক দ্যাট পাৰ্টিকুলাৰ পাৰ্সন অৰ দ্যাট পাৰ্টিকুলাৰ বডিক কয় যে আপোনালোকে এনেকৈ পাৰফৰ্ম কৰক যেনেকৈ আমি কৈছো, অৰ্থাৎ ইটস এন অৰ্ডাৰ গিভেন বাই দ্য কোৰ্ট টু এ পাৰ্টিকুলাৰ পাৰ্সন অৰ অথৰিটি টু পাৰফৰ্ম ইন এ স্পেসিফিক ওয়ে। দিস ইজ দ্য বেসিক কনসেপ্ট অফ writ. ইটস বেসিক্যালি এন অৰ্ডাৰ। তাৰ পিছৰ কথাটো যদি আহো যে ৰিটছে আৰু এটা আমাক কি কাম কৰে, কনস্টিটিউশনাল ৰেমেডিজ ফৰ দ্য ভায়োলেন্স অফ their legal or fundamental rights. গতিকে আমি রিটস মই ইতিমধ্যে কৈছো আপোনালোকক যে ৰিটছটো আকৌ কেতিয়া ব্যৱহাৰ কৰা হয়, when do we use writs? Basically, it is a constitutional remedy. Amar সংবিধানত থকা এটা remedy, constitutional remedy. আমি কেতিয়া ব্যৱহাৰ কৰিব পাৰো কি যেতিয়া when our fundamental or legal rights are violated, amar jodi fundamental maulik odhikar ba aini kisuman odhikar jodi bhongo kora hoy, whenever it is violated, we can take help of the writs, which is also a basic form of constitutional remedy. So jodi apnaloke ketaba answers o likhibo lage khub khohoske, what is a writ? A writ is an order given by the court to a particular person or a body or both to perform in a specific way. Tare agot apnaloke aru eta line likhibo pare writs or because the writs are basically available in article 32 and 226 of the Indian Constitution. And most importantly, writ is also a basic type of constitutional remedy which can be used by the citizens of India when their basic fundamental or legal rights are violated. Ekhini kotha jodi apnaloke likhe tetia hole apunar introduction part to baha jitu ami mane arambhoni part koru eta writsor jeta ami uttor likhibo jao hekhini apunar cover hoi jay. Kotike moi akbar repeat kori disu, we get the provision of writs in Article 32 and 226 of the Indian Constitution. Under Article 32 of the Indian Constitution, writs can be applied by the Supreme Court of India, and under Article 226, writs can be applied by high courts in different states. So, what basically is a writ? Writ is an order given by a court to a person or a authority or both to perform in a specific way, as well as it is a constitutional remedy that can be used by the citizens of India whenever they feel that their fundamental or legal rights are violated. So that is the basic introduction on writs. Etia, now we will talk about, ami writs kotha batilu, we talk about writs. And most importantly, মই আৰু এটা কথা কৈ দিছো ইয়াতে যেটা আমি ৰিটছৰ কথা পাতো, ৰিটছৰ আন্ডাৰত আমি আৰু এটা বস্তু পাও, that is judicial review. So কি হয় basic concept to, suppose if your fundamental rights are violated, you approach the court with applying a particular kind of writ, then what happens, the court looks up to it, right, that whether or not your fundamental right or your legal right is violated. And that is the reason when it looks to it, it reviews the situation. That is why writs can be also said as a means by which the judiciary uses the judicial review format. So that can be also a question, that under which article of the Indian Constitution maybe the judiciary or the courts go for judicial review. You may answer Article 32 or 226 of the Indian Constitution. So this is the basic starting. We are dealing with writs, and now we will talk about, so that we talked about writs. So how many types of writs are there, and which writ is applied in what cause? The writs ke prakarar ase aru he writs bur ami kunbur writs kenekwa situationot ami apply korim. Etia first writ to jeta ami kom, he writ to hoise the very first writ that is available is habeas corpus. So bekhekoi prothom jitu writ, he writ to amar hoise habeas corpus. Ketaba enuka prashnobur ahe, sometimes this question comes like, what is the basic meaning of habeas corpus? You might get options A, B, C, D, and you need to tick one option. So basically when we say habeas corpus, it means to have body of. So basically what habeas corpus means, what is the literal meaning of habeas corpus? The literal meaning of habeas corpus is to have body of. Etia basically our confusion writs ekane hoy because we try to memorize. So the basic way of learning writs or basic way of learning the Indian Constitution is that you need to get the concept. If you get the concept, it becomes very easy for you to remember. But if you go on memorizing without understanding the concept, it would be very difficult. So basically I'll try to make you understand how these writs are applied and what are these writs. The next part of it we will be dealing in the next episode of the writs under Indian Constitution.